Supreme Court of India, in the matter of HDFC Bank Limited versus State of Maharashtra, allowed the appeal and set aside judgment of High Court of Bombay. Court said that applying the said legal position to facts of present case, it is found that averments and complaints set out against the respondent number 2, Mrs. Ranjana Sharma, fulfill requirement of section 141(1) of the Negotiable Instruments Act, and this is not a case where trial against her can be aborted by quashment of proceedings. The High Court was completely unjustified in quashing the proceedings against her. Court said that the administrative role of each director would be within the specialized knowledge of the company or director of the firm, and it is for them to establish that they were not in charge of the affairs of the company. In view of this, contention of learned counsel for respondent 2 that the specific role attributed to directors should be set out in complaint does not merit acceptance. Reliance had been placed on National Small Industries Corporation Limited versus Harmeet Singh Pental case by the learned counsel for respondent 2 in support of proposition canvassed. Court said that if the learned counsel by such submission seeks to contend that the complainant in a section 138 complaint is obliged to plead administrative matters which are especially within knowledge of company and directors, then he is completely wrong in understanding the ingredients of section 141. As held in KK Ahuja case and reiterated in SP Money case, complainant is supposed to know only generally as to who are in charge of the affairs of the company. Considering these developments, the court, while quashing the proceedings, held that merely because somebody is managing affairs of company, per se they do not become in charge of conduct of business of company or the person responsible for the company of conduct of the business of company. It was further held that averment that accused were busy with day-to-day affairs was also insufficient to attract ingredients of section 141(1). Proceeding further, the court held that merely averring that accused were in charge of company was neither here nor there, as such averment was insufficient to conclude that accused were responsible to company for conduct of business. This is vastly different from averments in present case, wherein it was clearly averred that respondent 2 was responsible for day-to-day affairs and management and working of the accused 1 company. Court said that what is important to note is the repetition of exact words of the section in the same order, like a mantra or magic incantation, is not the mandate of law. What is mandated is that the complaint should spell out the accused sought to be arraigned falls within the perimeters of section 141(1) of the NI Act. Only then could vicarious liability be inferred against the said accused so as to proceed to trial. Substance will prevail over form. Harmeet Singh Pental case holds that, further, in order to fasten the vicarious liability in accordance with section 141, the averment as to role of the directors concerned should be specific. The description should be clear and there should be some unambiguous allegations as how the directors concerned were alleged to be in charge of and were responsible for conduct of the affairs of the company should be understood to only mean vis-a-vis the transaction concerning the issue of the check in question which are within the knowledge of the complainant. KK Ahuja case holds that in case of a director, secretary or manager as defined in section 224 of Companies Act or a person referred to in clauses E and F of section 5 of Companies Act, an averment in a complaint that he was in charge of and was responsible to company for conduct of business of company is necessary to bring case under section 141(1) of the Act. No further averment would be necessary in complaint, though some particulars will be desirable. They can also be made liable under section 141(2) by making necessary averments relating to consent and connivance or negligence in the complaint to bring matter under that subsection sets out the correct legal position. A harmonious reading of the judgments in KK Ahuja, Harmeet Singh Pental and SP Money case bring out the position that there is no obligation on the complainant to plead in the complaint as to matters with the special knowledge of the company or directors of the firm about specific role attributed to them in the company. Facts of this case were that the respondent number 2, Mrs. Ranjana Sharma, along with her daughter, Miss Rachna Sharma, and one Mr. Rakesh Rajpal, were directors of a company, MS R Square Shri Sai Baba Abhikaran Private Limited. According to complaint filed by appellant, accused number 1 company, along with respondent number 2 and other 2 directors, approached the complainant for grant of credit facility in form of revolving loan facility as inventory funding for the working capital requirements. According to appellant, loan amounts were extended and on account of failure of accused to repay outstanding dues, account of company was classified as non-performing asset on 27 March 2018 in accordance with guidelines issued by Reserve Bank of India. It was the case of appellant that check issued by accused for a sum of rupees 6 crore 2 lakhs 4,217 on deposit was dishonored for the reason account block. According to appellant, legal notice was issued to all the accused. However, said notice was returned back as unclaimed. Appellant thus prosecuted the company and three directors and prayed for appropriate punishment of imprisonment as well as direction to pay fine up to double the amount of dishonored check.